Good morning, everybody.
So, ladies and gentlemen, I'm just going to turn it over to Ms. Cindy Blackstock here. Ms. Blackstock, go ahead. Take it away.
Thank you. A very good morning to all of you from Treaty 4 territory here in Regina, where it's -17. So I heard Michael complaining about the breezes in Ontario, but I'm telling you, it is coming your way. It is a real honor for me to join you this morning at such an important time in children's lives. And I want to acknowledge the Elder's Prayer and the Corn Husk Doll teaching. That's beautiful. I learned something more about the Corn Husk Dolls today to get us going. And I really believe that this whole case has been spiritually guided and needs that positive energy to be brought to it. I'm going to be going through a bit of a presentation today, and then certainly I'd welcome your questions. So what we really want to talk about is equity for kids, but how do we achieve that collectively together? And I want to acknowledge all the people over the many decades in First Nations communities, in the non-Indigenous allies who have been pressing for fairness for our kids and pressing for respect and honor for our kids, including the veterans who we're paying specific honor to this week. One of the things that is really a big learning in my life is that the inequalities and the harms that arose from those inequalities in public services have been long known to the government of Canada. I think one of my major mistakes in the past is I assumed that they had failed to fix the problem of the unequal services, but they actually have chosen not to fix the problem with the unequal services, and that's a different thing. And how do we know that they've chosen to do it? Well, we echo back to the time of Dr. Peter Henderson Bryce, who was right there from near Six Nations of the Grand River in Mount Pleasant, Ontario, Canada's first chief medical health officer, who blew the whistle on the unequal healthcare funding for First Nations kids and how that was leading to the deaths of children in residential schools at the rates of over 50%. And this is in 1907. They had what Dr. Bryce said, medical science knows just what to do to save the children's lives. And the Laurier administration and Duncan Campbell Scott had it within their possibility to save those children, and they chose not to do that. We'll see similar reports actually throughout the decades, often recommending things like we need to get in and provide proper supports for families, for the quote Indian families. And what I had failed to do early in my career is actually go back and look at all those reports. Had I gone back and looked at all those reports, I would have understood that the government of Canada was choosing to discriminate against our kids, even though it knew about it, it knew about the harms, and it had the possibility of solving the problem. But we entered the scene in the wake of the Royal Commission on Aboriginal Peoples in 1996. And as you remember, one of the things that RCAP pointed out was the unequal funding for child and family services and how that was fueling the overrepresentation of First Nations children in care. And we got together with experts around the country, First Nations experts in the government of Canada. We chronicled that underfunding. It was then 70 cents on the dollar. So a First Nations family got 70 cents on the dollar for child welfare funding compared to other people. And there's 17 recommendations in this old report. And coincidentally, since we're going to be talking about C92 later, this is one of the reports where it has the top recommendation is jurisdiction in child welfare. But the government received the report, they acknowledged the report, and then they didn't do anything with it. And they asked for a second report. And we get sucked in for the second report too. And we do this, and it's a very detailed report, the series of Wande reports. There's actually 3 of them. And what we found then is that the inequality had grown. It had deepened for families, and so had the harms. We're seeing that First Nations children were going into care by this time at rates about 8 times more likely than non-First Nations kids. And the reasons are the same reasons that we're going to see later today, and that is poverty, poor housing, caregiver substance misuse, and domestic violence. Those are the fires that fuel the overrepresentation of First Nations kids in care. And the inequalities in those public service areas make it even harder for First Nations families and community and service providers like yourselves to address it. So we filed the case, the Assembly of First Nations and a Caring Society, in 2007, saying Canada's failure, or rather choice not to implement those solutions, was discriminatory. And the Auditor General weighs in 2008. They still choose not to do anything about it. And I think that this is an important concept that we all kind of just got to flip our thinking about, is that governments often aren't failing, they're choosing. And that requires a different type of response, especially because when they choose not to help address systemic discrimination, the price is paid by children and families themselves. You'll remember me saying in the just recently that the overrepresentation back in the early 2000s was about 7 to 8 times. Well, this is data from Dr. Fallon's study and the First Nations Incident Study, and I want to give a credit to the First Nations Advisory Committee, including Ken Richard from Ontario, who guided that work. Now, what we're seeing now in the 2019 data is that for First Nations kids, they're over 17 times more likely to be placed in out-of-home care. But 72% of the removals are done off reserve by provincial and territorial organizations. In fact, one consistent trend we've seen with the data is that First Nations agencies are far more likely to keep children safely within their nations than the non-Indigenous sector. So when we think about C92 or we think about child welfare reform, we have to make sure that we're not leaving the 72% of the kids behind. And I know that a lot of you are working to make sure that doesn't happen, but it's still a complication because of the split of jurisdiction on and off reserve. So when we talk about prevention, I think it's a very general term, but to be most effective in terms of addressing the overrepresentation of First Nations kids in care, we need to tailor our interventions to the problems that create the overrepresentation. And I want to step back and just say that same cocktail of disadvantage, the poverty, the substance misuse, the mental health trauma, the domestic violence, poor housing, those are the same factors that fuel mental health concerns for young people, participation in the juvenile justice system, etc. So if we don't address those core problems, then we're going to continue to see this disadvantage, no matter how much tinkering we do in these various systems. So with the prevention, we have an opportunity to go that way, but it's going to take multidisciplinary practice, the development of culturally based, for example, addiction centers that get at the collective trauma from residential schools is very important. And I also want to point out in this slide that back in 2000, when the Canadian Incident Study did a comparison of the risk factors between First Nations families, which are here, the light blue bars, and non-Indigenous, we wouldn't have seen this graphic difference in First Nations families. But what has likely happened, we don't know for sure, but what has likely happened is that Canada's choice to continue to discriminate just compounded the trauma for people. So we're seeing more families now with higher needs. And certainly that's true for children in care as well, or children even you're trying to keep at home have higher needs. And we see that here in this slide. So the challenge of supporting children is becoming more difficult, requires a multidisciplinary response, and is more costly. We're looking at things, for example, like fetal alcohol syndrome, you can see is far more likely in a First Nations child. That's owing to the addictions, which in turn is owing to the collective trauma. Those types of things are going to require lifelong supports and care. in the family home. And so we need to kind of find a way with this prevention money to get at the families who are the most traumatized. Sometimes, as you know, those are the families who aren't at a place of being really able to welcome any kind of a voluntary assistance. So how do we make sure we include all the families in the support regime going forward? But all of these needs have implications for costs as we're going to go get forward. Now, one of the things we just launched, and I just want to put a shout out, is we are inviting experts to come and talk on Spirit Bears podcasts on various topics. So we've had Professor Naomi Metallic and Dennis Burnside talking about C92. We've had Dr. Palmater talk about colonial politics, and we will also have Dr. Fallon in an upcoming series talking about birth alerts. One of the things that you'll note is that the literature on birth alerts, for example, is that there is no real convincing evidence that they work, and there's also no convincing evidence they don't work. And then I think the narrative around birth alerts, we're all looking for ways of solving it, but unless we can link it to those fires, then we're not going to be able to make the difference that we'd like to. So check out those podcasts. They're free of charge and they're on our website. So let's turn to the case. This case has now been going on. It'll have its 17th birthday on February of 2023. I'm going to be going through three different buckets here. One is the compensation from the Canadian Human Rights Tribunal. Now, compensation from the Canadian Human Rights Tribunal is awarded pursuant to the Canadian Human Rights Act. And that act allows for funding to go to individual victims at a maximum amount of $40,000. Those victims retain their right to litigate against Canada for more compensation. And there's also no other party gets a benefit. So there's no legal fees being paid as part of the compensation, nothing like that. It's any money paid under this regime goes strictly to victims. Then we have the class action. And the ways this came out is that there was a class action that went back till 1991 and included some of the people from the CHRT. And you might remember that at the time, the Prime Minister said, well, we're not paying the CHRT compensation because we want to pay the CHRT people more money, which would have been a good thing had that actually occurred. And we'll get to some details on that in a minute. But the most important thing I want to talk about today is how do we stop this discrimination against our kids and make sure it doesn't happen again? And that's in long-term reform. And you can see the various parties down here involved in these different groups. So as I said, when we look at the Canadian Human Rights Tribunal compensation, which is the CHRT, and we contrast what's called the FSA, which is the class action agreement, we see some things. And one of the good things about the class action is it goes back to 1991, and it includes, it does provide more compensation than $40,000 for some CHRT entitled victims. And we need to really acknowledge those positives. The downside is that it had the effect of actually taking away the $40,000 entitlement from some children in care and from the parental estates. And this is problematic because it really is setting a precedent where the tribunal would be taking away human rights that it already awarded. And it would also be setting a precedent where outside proceedings or outside parties could take monies away from children in care. It's interesting that actually just a few months ago in Manitoba, the Manitoba Court of Queen's Bench ruled on a case where the Manitoba government was trying to claw back the children's special allowance from children in care. And the Manitoba court said, no, Manitoba, you can't claw back that money because that money is for the individual children. It's not your money. And I think that same principle applies here. Compensation is unclear for the Jordan's principal classes. It's just that they're working on the criteria in the class action. They don't know if these people will get their $40,000 or what the situation is yet. And under a class action, you waive your right to litigate against Canada for more money. So you just get whatever is in that agreement, and you can't go after them for more. And Canada gets a wide release of liability. So we talk about these children who are being left out. So who are they? Well, they're kids in non-ISC funded placements. And when we look at the data from the Canadian Incident Study, this is the most frequent type of placement. It's called informal placement in the Canadian Incident Study. And you can see that it really is used often, and often used, frankly, because it's the best idea, right? If you can keep kids, say, with a neighbor's, a friend of a family or something, then that's far better for the child than placing them with a stranger. Now, I will note that not all of these children in this upper category would be eligible under the tribunal's orders, but many of them would be. How did the tribunal come to make the ruling that it did a couple weeks ago? Well, the tribunal's orders had stood. It awarded the $40,000. Canada appealed to the federal court and lost. So Canada was ordered to pay the $40,000. And it should have done that. But instead, it launched this class action piece. And the way that hearing happened is that in the class action agreement, there's this clause where they would have to come to the tribunal to get an order saying that their final settlement agreement, the class action agreement, satisfied the tribunal's orders. Why? Because Canada didn't want to have to pay anybody who was left out under the Canadian Human Rights Tribunal. So the idea is replace the tribunal's order with this final settlement agreement. And the AFN also, as you can see, was to lead the legal proceedings and to publicly promote and defend the agreement. That hearing happened in September of this year. And for those wanting to watch it, you can, thanks to the Aboriginal People's Television Network that webcasts the entire proceeding. So there's the immunity clause. I'm not going to go into it now. I'm not a lawyer, but it seems to be pretty wide sweeping in terms of some of the immunity that Canada is granted in the class action final settlement agreement. So what is our view? Well, going into that hearing, it's very clear that $40,000 is the floor, that we cannot take legal entitlements for children away from children. And we also didn't want to set a precedent, for example, on long-term reform, where some third-party agreement could come and encroach on the rights of children. We view the Canada as having a duty, a legal duty, to immediately pay compensation to these victims. It's Canada's choice not to do it. And we feel that that is something that they need to be held accountable for. And we also believe that free, prior, and informed consent applies to matters affecting First Nations children and families, and that Canada needs to withdraw its appeal at the Federal Court of Appeal. So what happened is the tribunal made the order of $40,000. The federal court upheld it. Canada then filed an appeal to the Federal Court of Appeal, but that's just hanging out there and hasn't been resolved yet. It's and we'd like Canada to withdraw that. So these were the positions we put before the tribunal. Now, the tribunal heard from the Assembly of First Nations, Canada, and other parties. And they also heard from the Caring Society and the Canadian Human Rights Commission. And they issued a letter decision on October 25th, 2022. So it, first of all, commends many aspects of the compensation order. But it says it doesn't fully satisfy the tribunal's order because it disentitles some victims. And this is an important difference. Like you might say, well, some people are being left behind, but this is a little bit different than that, in that these kids have a legal entitlement to $40,000. It would be taking that legal entitlement away from them. It reduces the entitlements for others, takes it from 40,000 down to about 20,000 for some of these folks, and introduces uncertainty for others. There's also the tribunal's concerned about what's called the class action opt-out, which is when you run a class action. I'm learning about all this too, but you actually have to opt out of a class action. You don't opt into it. And for these Canadian Human Rights Tribunal victims, who are entitled to 40, what you'd want to know is, well, do I get more out of this class action or less? Unfortunately, we don't know. And the opt-out period, the period which you can kind of opt out of this class action and to secure your $40,000, the clock is actually running right now. And you're going to be in the class action by February of 2023 unless you opt out. So this is being worked on, I know, by Class Action Council, but watch that particular piece because we want to make sure that people have a choice. And the tribunal's decision also has a path forward for the class action. So this idea that the tribunal rejected fully the final settlement agreement is not correct. They recognize it, but they say that there's the agreement should be amended to make sure that children are not left behind. They also recommend that Canada should pay the money into a trust so it can build up interest to make the compensation a higher amount, and that Canada also has its option of paying more money. So you can read the full decision on fnwitness.ca. The decision with the reasons has yet to come out, and Canada and the Assembly of First Nations and the other parties have until I think it's November 25th to file an appeal. I certainly hope they don't. I hope that we can all get this resolved and that the class action agreement is amended in alignment with the tribunal's decision. So this is what our next steps are. We want also supports for the victims. It's unclear to us under what kind of supports are actually available under the class action. So until those supports are in place, we're advocating that any child who is receiving the $40,000 when they turn 18 ought to receive post-majority, whether they're Jordan's Principle or Child and Family, so that you're able to, at a community level, tailor some supports for these kids. And yeah, we want to see Canada pay up because it's just this legal finagling that it's doing is really creating another injustice for kids. One kind of fun thing that we've been doing is working with the Youth and Care Network to develop financial literacy tools. So these are all developed by young people for young people. And actually, I find them to be really helpful too. So anyway, these are also on our websites, like protecting yourselves from scams. We have them in French, we have them in English. So if you have young people in your community, these are tools that you can use. So yeah, so that's on compensation. And I have to say that the whole thing around class actions is a learning thing for me. And I know you have many skilled lawyers in that room who can help you unpack that. I really recommend everyone get independent legal analysis of that decision so that you understand what it actually says. So let's switch over to the most important part of the work, which is the work you do on a daily basis, which is keeping families safe. And let's talk about the long-term funding for Child and Family Services and Jordan's Principle. When you think about non-discriminatory funding, what I have been taught by so many folks over the years is that the most important thing is the funding structure, how the money moves, what are the rules around how you can use the money. That would be important, especially when we're talking about those interdisciplinary services. If you want to put some of this prevention money in partnership with Addiction Center and be able to run a family-based addiction center, for example, you need the flexibility to do that. You also need to be able to enforce the funding obligations. So to make sure that if funding is insufficient to meet the needs of your community as they change over time, that you can go back to Canada and actually get more money for the families so that you're not ending up in a bad situation where you're having to cut services that community members really deserve and need. And the least important thing, although very important, is the initial funding level. And the reason that is least important is because if they give you a large amount of money and they adjust it by inflation or population, the experience on Child and Family is that doesn't work very well. It'll be okay enough for a few years, but then you're going to go into a deficit. And how this works is, for example, we think about the pandemic. If you were on a fixed amount adjusted by population and inflation, and then COVID-19 happened and you had to retool all of your services, as many of you did, to meet the needs of community. Well, those adjustments for COVID-19 wouldn't be covered by such an inflation adjustment or population adjustment. You would have to take that out of your operating. It's that kind of stuff that creates problems for First Nations. So we all know the work of the Institute of Fiscal Studies and Democracy by Helena Gaspar. And what we're trying to do in this work is really come up with a needs-based funding approach. And what that means is needs of your kids in your unique communities. And back in 2019, they did a phase 2 report. But I want to make a couple of notes here because I think there's some misunderstanding about this report. So first of all, they came up with child well-being indicators, which I think are very useful to have. But we'll need capacity at the community to be able to measure those, to know where our kids are today and how our interventions over time are impacting them. So that is good. And IFSD 2 is only based on agencies because that's really what we had back then. I know it feels like the world has changed so much in the last few years, and it has. But it's based on agencies with existing capacity to deliver services. It was not the amounts that you have there, like the prevention amount and the poverty, was not intended to be split. And this is an important thing to note. So it's not to say that First Nations shouldn't get prevention at all. It's just that there needs to be capacity for that First Nation to be successful in delivering some of those prevention services, just as there needs to be capacity for an agency to also deliver prevention services. This is a yes and type of proposal. And what we're trying to get at in the phase 3 is what does that actually look like when you have First Nations delivering some of the services and agencies delivering others? What types of supports need to be built in? And that work is underway. The other is there needs to be more work done for First Nations without agencies who are receiving all their services from the provinces. That work is also underway. So it would be incorrect to kind of take phase 2 and then apply it to the scenario right now where we have First Nations delivering some prevention and First Nations agencies providing some prevention. There's some good things in here, but we just need to make sure that we're understanding that the work being done in phase 3 and for First Nations without agencies is going to fill our knowledge gaps. And hopefully that work will be available to all of us by the spring of next year. So this brings me to the timelines. You've all read the agreement in principle. It's out there publicly. And you're going to note a couple of days here. We signed the agreement in principle back in December 2021. And back then, we had hoped that there would be a final settlement agreement and the tribunal would end its jurisdiction by the end of the year. The tribunal has written a letter saying that it needed 60 business days of all the materials to be filed before it could end its jurisdiction. That time has come and passed, and there hasn't been a motion for it to end its jurisdiction. And the most recent decision on compensation means that that's unlikely to happen in the near future. Now, I think folks are trying to come up with a final settlement agreement. We'll see how that works, but I'm personally really hoping that we are able to ensure that whatever's in a final settlement agreement really embeds the findings from the IFSD phase 3, that we really have the work done on Jordan's principle. And the reason that that's important to me is not just because it's research, but because that's how agencies and First Nations are having their voice into the process. Knowing what it looks like on the ground helps us make the best decision. And that's the type of content and detail I want to see in this. So for me, when I think about a final order from the tribunal, I want to see a reform funding approach for Jordan's principle. That means we embed the current orders as the floor, that we look at the data analysis, which I'll take you to in a minute, and correct some of the ongoing flaws that we are seeing in the implementation of Jordan's principle, and that we support community navigators at a community level to ensure that Jordan's principle is available to every child across the country. We need to reform the department. The department has done harm and said they're sorry so many times, only to go on and do more harm and have to say sorry again. So we've developed an expert advisory committee to look at doing an evaluation of the department, but also taking immediate steps to fix the department. And I'll talk a bit about that in a minute. And then for Child and Family Services, well, the work with agencies is ongoing, including thanks to the ones in Ontario who participated. The analysis of that work from IFSD will be available in the spring of 2023. And First Nations receiving prevention with or without agencies, that work as well, hopefully maybe a little bit sooner, January to March of 2023. Now, one of the headlines that came out of the papers in the wake of the Tribunal's decision was that the $40 billion deal was torpedoed, I think was the language, which was really unfortunate and not factually correct. First of all, the $19.08 billion over 5 years for long-term reform is separate from compensation. There's nothing in the final settlement agreement for compensation that links these two. The second important thing is when we look at this amount, 75% of the $19.08 billion is subject to CHRT orders by the Tribunal. So these are existing orders. Now, the only way those existing orders go away is if there's another order. And then we see 10% is for remoteness, 9% are these top-ups for poverty, etc. And then 6% is old money. So what we need to do is press Canada to release the 19% that's going out the door. That's important. But I want you to also understand it's only for 5 years. There's nothing yet from the government about what they're going to do for year 6 and beyond. And I can only speak for myself, but I certainly didn't get involved in this process to only get non-discrimination for 5 years. Now, here's the Government of Canada's own pie chart. And just so you can see it, this is a public document created by Canada. And I just wanted to show you because it aligns with what I just showed you in our Caring Society calculations. You see this gray part of the AIP, but if you scroll over, you'll see that's subject to the most recent order. And that's the orders on prevention and post-majority, or pardon me, prevention and post-majority care and those kinds of things. So a lot of this funding, about 70, I think theirs comes to 74%, is already subject to Canadian Human Rights Tribunal orders. So long-term reform on Jordan's principle is not done yet. We have some analysis by the Institute of Fiscal Studies and Democracy on Jordan's principle, and this is based on departmental data. But we haven't gone out and done the work at a community level to talk to all of you about Jordan's principle and how it can make the best benefit for kids. One thing I will say about Jordan's principle, and this just aligns with what the elder was saying this morning about how the sacredness of children. We would ask on behalf of the family that people do not use the acronym JP. Consistent with many of our teachings across the country, when we say the child's full name, we call their spirit and we honor the spirit. So please say Jordan's principle. But the analysis of the departmental data is very instructive in terms of where we need to go on long-term reform. This report is available on fnwitness.ca and also on the IFSD website. And what it shows is that the requests for Jordan's principle have gone up 625% in 4 years. And that's a good thing because it means children's needs are being met, but it's still going up. It hasn't plateaued. So if we were thinking, for example, of transferring this program to First Nations, it's going to be difficult to budget enough money because we don't know how much the need is. It's still driving up at an exponential rate. 50% of that 625% is between 2019 and 2020. And some of you might be saying, well, COVID-19 must have driven a lot of that. Well, only 10% of the 625% increase is driven by COVID-19. Most of the others are unmet needs, and many of those are low dollar requests. So not low impact requests, but it really speaks to the poverty of families, things like getting baby formula, things like getting transportation so they can take their children to medical appointments, that kind of stuff. And half of these requests are between $100 and $999. But these low dollar amount requests go through the same red tape as something for $5 million. And that doesn't make any sense, right? So one of the things that we think could be done is actually having a presumption of yes for these low dollar amounts, so that the focal points are not going through a lot of red tape, and neither are your navigators. They're able to say, well, there's a professional letter here, consent of the guardian, it's for $200. It's going to cost more to even review it. Let's presume it's approved with those safeguards. There's a lot of differences in the determination between regions. And I'll sadly say that Ontario, I think, is one of the regions where there are the most problems in the department in terms of processing requests within timeframes, as well as in the level of denials. We're seeing long periods of time for the department, even when they approve a complaint, to actually pay for it. So I think that it shows us that these regional differences sometimes can be positive, but in this case in Ontario, it's not that positive. And there's something they could learn from regions that are doing a better job, like next door in Quebec. And the departmental region processes most of these within timeframes. We are also finding Jordan's principles plugging holes in other underfunded programs. So things like services for kids with autism, education, medical transportation. Jordan's principles become the Band-Aid to plug the other areas of inequality. And so one of the solutions is to plug those areas of inequality so that no one has to apply for services under Jordan's principle. They're getting what their children need and deserve without application. So what do we need to do on Jordan's principle still? Well, we need to find out what these shortfalls look like in these other underfunded programs that Jordan's principle is filling. We need to cost out the community navigator program. We know there's some excellent navigators out there, but we're also hearing stories that they are overwhelmed with the amount of work and they can't keep up. We're also need to ensure that the department is complying with the existing orders. At the Caring Society, we're particularly concerned with how the department has been managing urgent cases. And in fact, in some cases, we've had to step in and fund those cases ourselves, just so that children got the help that they needed. We need to work and calculate the growing costs of Jordan's principle. So we need to see where that 625% increase is going to level off so that we have some predictability in being able to say how this is going to roll out over years. And we also would like to kind of think about approaches that might bring those child well-being indicators from the child and family services stuff over to Jordan's principle, so that we're measuring outcomes for children across multiple areas. And then that all leads us to the long-term funding approach. So this is what still needs to be done before we're finished the work on long-term reform. And this plugging holes in other underfunded programs, well, that's a Spirit Bear plan, right? This was passed by the Gitxsan Assembly in 2017. And it requires Canada to cost out all the areas of inequality for First Nations kids. Things like education, early childhood, child and maternal health, recreation spaces, culture, all the rest of that. And then develop something like the Marshall Plan after the Second World War and fix those problems. Well, Canada has never adopted this. And I think that's really unfortunate, because by not adopting it, they're choosing to allow the discrimination in these other areas to persist. And what we know from history is that when we work together collectively, we can have good results for our kids by using legal strategies, if necessary, to remedy the inequalities in Jordan's principle and other areas. But having things unattended, where that legal pressure isn't there, we see these inequalities being kicked down the generations by the government of Canada, at great harm to children themselves. So when I think about long-term reform, here's some questions I have. What happens in year 6 and beyond? So if we have a baby born today, what does the world look like for them when they're in grade 1 and in grade 2 and grade 10 and grade 12? How did we make sure that this was the last generation Canada hurt? What funding approaches are First Nations and First Nations agencies transitioning to? So what does the new world look like for you? And what say do you have in when that happens? Another clear part of this transition is that I think regardless of whatever decision you make, you shouldn't lose out on any money. When you're doing due diligence about this is where we are, this would work best for us, there shouldn't be a penalty for that type of good governance and decision-making for kids. What happens if the tribunal is gone? And by the way, when I say the tribunal is gone, that would mean they've issued a final order and we couldn't go back for non-compliance orders. We've gone back now, I think 23 times there's been non-compliance and procedural orders. And that's how we got things like Jordan's principle and the prevention money. We couldn't do that anymore. We'd have to start off with a fresh complaint or use an alternative dispute resolution mechanism that would be in the final settlement agreement. But what happens if the tribunal is gone before it's clear what measures Canada will adopt to stop the discrimination and prevent the recurrence? Remember those reports at the beginning where they said they were a part of them, they agreed with them, they were reviewing them, and they never implemented them. So how do we make sure that we leave First Nations and agencies with a bunch of tools so that you can enforce the funding obligations against Canada? Why is Canada holding back some of the 19.08 billion, especially for remoteness, instead of paying it now? The tribunal in its 2016 decision specifically speaks to remoteness as being one of the areas contributing to discrimination. Canada ought to be paying that now. How do we ensure accountability to First Nations during the negotiation process and support free, prior, and informed consent as we're rolling this out? And what happens to Jordan's principle, given that there's no long-term funding approach yet? So these are some of the questions that I'm looking at. There might be some of the things you want to think about. We're also seeing some interesting stuff happening legally. This one's related to the Spirit Bear plan. It's a case out of Quebec where the tribunal, Canadian Human Rights Tribunal, ruled that the policing funding was unequal and was discriminatory. Now, Canada is appealing this, but it's using many of the same procedural arguments that it did in the child welfare case. It feels to me like they're trying to erode the CHRT pathway to address longstanding inequalities in other First Nations services. So we are working at the Caring Society to support the First Nation to try and address these jurisdictional arguments that Canada is putting forward. Because at the end of the day, if Canada won't choose to remedy the discrimination, then we have to use legal methods to do it, including a tribunal. Today, our friends in the US are arguing to protect the Indian Child Welfare Act. I just want to recognize them, show our support to them as they try and defend against a case where some non-Indigenous parents are arguing that the Indian Child Welfare Act is unconstitutional. well, of course, you know, I'm not going to make much of an editorial comment about the US Supreme Court, but we know its recent decisions have been very egregious to human rights. So watch this case, though, because this links into C-92, because ICWA was used as a basis for C-92, this Indian Child Welfare Act that the US government and, or pardon me, the Supreme Court of the United States is looking at today. So the hearings on C-92 will happen on December 7th and 8th in Ottawa at the Supreme Court. We're unsure whether people will be able to go there in person or whether you'll have to view online, but check the Supreme Court's website. Quebec is also arguing that C-92 is unconstitutional. They're saying that really child welfare is provincial jurisdiction. And then even where that argument doesn't apply, they're saying that Parliament doesn't have the right to determine the scope of Section 35 of the Constitution, so the whole thing should be thrown out. Canada's on the other side saying that, you know, the C-92 is constitutional, but one of the unfortunate things about this is we have two non-Indigenous governments fighting over our kids, and we as First Nations or First Nation service providers, all we can do is intervene in this case. So the Caring Society is an intervener in this case, and our submissions are, I just want to put a shout out to David Taylor and Naomi Metallic, who are leading the work on that for the Caring Society. And of course, the amazing Sarah Clark, who's there with you in the audience, who has been doing some great work for the Caring Society on children's issues for many years. So is C-92 the solution to all the child welfare issues? I'd say it depends. And why I say that is because I'm not sure that C-92 is actually jurisdiction, as I understand it. When we've looked at First Nations laws across Canada and around the globe, we haven't actually found a child welfare law yet. We found kinship laws, family laws, that kind of stuff. And those laws take into account education, spirituality, looking after children's health, all kinds of stuff. They aren't specifically child welfare. C-92 takes a more Western child welfare approach. It entrenches a child welfare approach. So is that actually jurisdiction? Is that reflective of the traditional laws of First Nations? That's a decision that has to be made by each First Nation. And even if it isn't, that's okay, as long as that's a conscious choice. The other is C-92 is one option to affirming self-government, but it's not the only option. So what about other options for drawing it down? Can you do it directly under Section 35? Could you just affirm inherent right or through your treaties? All of these should be on the table. And it also should be on the table that you receive the support you need in order to explore these other avenues. Another key question is that what are the problems in child welfare that jurisdiction can actually fix? Remember, we were talking about the fires, the poverty, the poor housing, the substance misuse, the collective trauma. What can jurisdiction fix in those areas? And specifically, what can jurisdiction fix if the federal government continues to fund those areas in an unequal manner? There are some good elements of First Nations laws, but just being really clear about what are the remedies jurisdiction can fix, and then what are the things that equitable funding can fix, and what are some of the things that community interventions or other types of interventions can fix. That is really important, because sometimes the government likes to use self-government as a shiny penny. So now we get to the money. When C-92 was passed, the government refused to include many First Nations submissions and calls that there be clear funding obligations by Canada in the Act itself. If you read the Act closely, there's no real funding obligation for Canada. The only thing they need to do is discuss funding. And even there, they don't need to do it. They can do it. So we need to realize that funding of laws is part of jurisdiction. We can't fall into the trap where Canada says, look, you take jurisdiction now and the funding, we'll talk about that later. Because the funding is the way that you give life to your law, how you make a difference for kids on the ground. So it's really, really important to figure that out. And it's also important to understand that if you draw down C92, are there any implications for funding in other areas? For example, if you include a broad term like prevention in your C92 thing, does that have any implications for families who are coming forward with a Jordan's principle request? And how will the buyers, the drivers of the overrepresentation be addressed in the law so that your law can have the desired benefit? What we don't want to do is have all these areas like poverty and poor housing that are continuing underfunded be unaddressed, and then you put your very thoughtful law on top of that. It's almost going to be like putting a law on top of quicksand. You won't be able to have the desired effect because the inequalities and the injustices in all these other areas will continue to be there. And to think through options, if you do want to go down this route of a full or partial jurisdictional model, what makes the most sense? I often say to people, when it comes to Canada and anything that they're offering up, I go back to my dating days and I always think, I want to date Canada before I get married to them. And especially in this situation where there's a lot of unknowns right now with our own the Supreme Court challenge, all the rest of this stuff is still up in the air. So my overall advice is, of course, be guided by your elders, by your traditional knowledge holders, these amazing experts that you have on the ground who do great work every day in First Nations, Jordan's principle, as well as First Nations agencies, and then take it slowly and do it in a graduated approach. Spirit Bear, we got another bunch of tools to give you. One is we have the calls to action from the Truth and Reconciliation Commission. And one of the things that really keeps on coming back to me is that the survivors' top calls to action will have to deal with this generation of children. So again, this kind of our obligation is in ensuring their grandchildren can grow up in a society where they have their basic needs met, where they can be respected and honored for who they are. So the spiritual undertones of the work that we have to do is really quite profound. And I want to recognize all the survivors and the children who are lost for all of their sacrifice to bring us to this particular place, to this place of opportunity. So how can we all help? Well, number one is, I think the Spirit Bear plan, we need to move on that and plug the holes in the other underfunded programs, particularly poverty, poor housing, addictions, mental health. You need to express your views on long-term reform and compensation. That can be done through the IFSD research, but also I'd really recommend that you get a hold of the parties, the Chiefs of Ontario, Anishinaabe Nation, of course, are interveners in the Canadian Human Rights Tribunal case. You can speak to those folks, but you can also write to all of us and say, this is what we think about this. This is important to consider. Contribute your ideas throughout the research reports and on any long-term reform proposals. I actually started my career working on the ground and frontline work for about 13 years. And I still remember the days when the government would come out with what seemed like a good idea to them, but actually was totally not what we needed on the ground. And we want to really make sure that doesn't happen. And so strong collaborations between First Nations experts who are working with children and families directly, and those of us who are sitting at that negotiating table is absolutely essential to being able to get the right type of solution that's going to work for kids as a minimum standard. I think there should be transparency in the negotiation process for the reason is we need ventilation. These are other people's kids. We need to make sure that these solutions that we're going to be leaving as a legacy honor what the survivors have asked of us, provide a minimum standard from which below Canada cannot slip, and ensure there's a clear and effective plan for Canada to eliminate this discrimination and make sure it doesn't happen again before we say goodbye to the tribunal. I want to see these solutions entrenched in very specific legal orders that would be a legal order tool for First Nation, as well as anything we can come up with in the final settlement agreement. So this is how to get a hold of us. We have all kinds of tools on our website, and we always remain open to your ideas and your expertise. I want to thank ANAFCIO for all the excellent work that it does. It certainly has been a guiding light in kind of my work and helping teach me about all of the important things that each of you are doing in your work every day. And I think I'll leave it right there. And wish you all a very good afternoon. I don't know if you have any questions or how you'd like to proceed.
Miigwech, Ms. Blackstock. What we'll do is we'll, if there are any questions, we ask that you get right to the question, as we are being mindful of the time. So if as you can see, we have our microphone stands. If anybody has any questions, Cindy's here to answer them. So there we go.
Good morning. I'm from Akwesasne, and we're going to start a First Nations, a Akwesasne Child's Rights and Responsibility Law. Now, you told us about what are the things that we need to look at. What do you think long-term should be elements of the law we're going to be developing?
Well, thank you for that. And, congratulations on that important work. When I look at the provincial laws and the child welfare laws that exist in the United States, there's one definition that has been consistently problematic, and that's the definition of neglect. Neglect, when we hear the word neglect, especially when mainstream people hear the word neglect, they think it's that families have the resources to keep their children safe and well and are choosing not to do it. But what we know in our First Nations experience is that it's often systemic discrimination, like the underfunding of housing, the underfunding of addiction services, all of the collective trauma from residential schools and other areas. That is creating a scenario where families are at risk, therefore children are at risk. The definitions of neglect in provincial statutes often run like First Nations, the child is being neglected because the family is unwilling or unable to provide X. What I want to do is ensure that we're holding families' feet to the fire for things that they can change, but not for things that they can't change. They can't change the fact that the Department of Indian Affairs has them living in a moldy, rundown house, and that there's such a housing shortage that there's 15 other people living in the same house. We have to address the injustices that put those families in there. We have to avoid the codification of structural discrimination as a parental deficit. That, to me, would be job one of any particular act. The second thing is really ensuring that we are providing a multidisciplinary approach to address the realities as they exist on the ground, providing the supports, for example, for children with fetal alcohol syndrome, and then for parents who now have fetal alcohol syndrome, to making sure that we are working in an interdisciplinary way for children, for example, with autism or other types of special needs. So making sure the law is structured in a way that it invites that type of multidisciplinary type of approach. And we did an evaluation, and I'll try and pop it in the chat even after I'm gone, of something called the Touchstones of Hope, where we worked with communities to surface these First Nations laws. And in the appendices of this evaluation, you're going to find the various elements of the laws that were in common across diverse First Nations. And that might be something interesting for you to look at for your nation as you consider the work that goes ahead.
Yeah, well, thank you for all your work.
Hi, my name is Robin Halliak. I'm the program manager with the ICFWB program, which is prevention BRS kind of program through Mattawa First Nations Tribal Council. So my question to you is, through this year's kind of change in funding with BRS funds, identifying the amount for on reserve versus off reserve. So on reserve needing to go through the Jordan's principal application process, and the on reserve having the established allocation amount based on population. That change was almost a step backwards. Living in the north, our communities are, our families are very nomadic. So they'll spend a season in the city and then they're back to their community. It's back and forth. It becomes a jurisdictional nightmare, to be honest. So there's that question. The other question that I have, this is a two-part, is when we talk about prevention services, my question becomes, when we provide prevention dollars to, you know, our Indigenous child welfare agencies, is this not a conflict of interest? Are we providing dollars to do prevention with child welfare, but yet after a family gets 4 or 5 POs, is that sometimes failure to provide when we're looking at keeping a file open or closed? I have run into this, and this is the question I put out there.
Well, as usual, fabulous questions. I'll begin with your first one on jurisdiction. This Jordan's principle was actually intended to resolve these types of jurisdictional disputes. And it meant that when a child needed a service, the government of first contact provides a service and then figures out the jurisdiction later. We need to kind of think about how we can apply that to remedy these on and off reserve quagmires, which are ridiculous. I agree with you. I grew up in northern BC, so we were on and off. You know, a lot of families move on and off on a regular basis just to kind of get necessities of life. There was an order from the tribunal that I think that we all need to be taking a closer look at, and that is with respect to Jordan's principle. Originally, when the feds rolled it out, they only restricted it to kids with Indian Act status on off reserve. And they said, well, yeah, okay, we'll provide it off reserve, but only if you have if you're Indian status. And we found a family actually out of Ontario, and just want to commend the family because the family's initials are SJ, and I can say that because it's in the legal record without compromising them, but I want to honor them. And that case led to a decision by the tribunal that it's not status that matters in terms of the federal funding for Jordan's principal off reserve. It's recognition by the nation that matters. So if you recognize that child to be a member of your nation, the federal government has to pay for Jordan's principal. Another part of the order that often doesn't get a lot of airtime, but should, is that the government of Canada in that order was ordered to pay First Nations to develop recognition processes for the purposes of Jordan's principle if they didn't have it. So if you are looking at going towards C92, this is something you're going to need anyway. So why not develop it for the short run for identifying children living off reserve who you recognize, and then use that also as a bridge to your work on C92. That order is really, really important. And another part of that important order is that we're so used to kind of the starvation system where the feds give you a chunk of money, and then if you have more children to serve, then you get less per child. But this order made it clear that it's not a question of taking a fixed pie and making more slices. It's about making a bigger pie. So by including these children who are recognized by their nations off reserve, we're just giving children more benefit. We're not taking it away from other kids. So I will, and I know Sarah's there. She probably knows the order number right off the top of her head. But I will put it in the chat so that you have it. I think that recognition thing is something we all should be looking at very seriously to avoid the types of problems you're talking about. In terms of prevention services, I actually look at it as a yes and type of scenario. And I'll tell you why. I think that your point is fair enough, that some families feel like they will accept prevention services if they're offered by a somewhere other than a child welfare agency. And that is more comfortable for them. And that should be an option. But if we strip agencies of all of the prevention funding, what's going to happen is they will get the families who are probably in the most crises, and they won't have the services there to try and stabilize kids in their family homes. Keep in mind that information I shared at the beginning of my presentation is that although we've seen a climb of 17.3 times more likely for First Nations kids to go into child welfare care, the bulk of that is for mainstream child welfare authorities. First Nations agencies, as a general rule, are far more likely to be able to keep kids in their families and keep them safely in their communities. And we need to make sure they have some of those tools to be able to do that. We don't want removal to be the only tool in the toolkit. That's why we started this case in the first time. So creating holistic, coordinated services that meet the whole range of needs of families and don't contribute to kind of implicit bias or disadvantage, I think is really, really important.
Thank you.
We have time for one more question. Okay.
Hi, Cindy. My name is Nova Cook. I'm honored to be here today with all of these wonderful people. And you just reminded me that I did touchstones at Couchin Tribes with you about a decade ago with Lotmatilson on Child and Family Services. Wonderful work. My question is specific to Jordan's principle, and you touched on the issue, but I'm hoping for some more immediate steps. So I work for an off-reserve child protection agency where, as a part of our truth and reconciliation commitments, we've been able to bring in a part-time Jordan's Principle liaison worker who spent the last couple of years writing Jordan's Principle applications for First Nations families that we're working with. And initially what we were able to do was pay for what was needed, hope that it gets reimbursed, get approval, and then the money would come. At some point, the Indigenous Services has said, nope, they're going to pay families first, then they're going to pay Indigenous agencies first, and non-Indigenous agencies will wait. And so it has had so much impact because we don't get payment. Even when things are approved, there's promise to pay, the money doesn't come, that we now are no longer able to pay. We're not able to provide that funding up front, which has direct and immediate impact on the families we serve. Our families don't have money to pay and be reimbursed. And so what is it that we can do from a level of advocacy to get this, like you've spoken to the bigger issues with Indigenous services, you've talked about some steps with the Tribunal to talk to, to express to AFN and other parties, but what can we do to actually advocate for this process to be repaired? Because it is, in the past 2 years, it's had dramatic impact on the service we're able to provide.
Yeah, thank you for your question. We have two team members at the Caring Society, Brittany Matthews and Jennifer King, who are often in communication with navigators and families from Ontario about the problems that they're getting, experiencing, not only just trying to get their cases heard by the department and determined, but then once it is, then the payment issue. It's a huge issue in Ontario. In fact, we had a service provider brought to our attention who is owed $250,000, who is actually going to have to close down their practice. And these are for approved Jordan's Principle cases. So it's a huge issue. Couple of remedies. One of the things we've been pushing for are something called acquisition cards. That's basically a federal government credit card where they could pay right up front the services that are needed for that person. I would be speaking to your region to find out who has that acquisition card and why, when are they going to be using it, so that you're not having to pay up front. Second of all, Canada is required to meet the needs of the child. They should not be relying on third parties to try and front the money. And I know what that's like because we do it here at the Caring Society, like I was sharing. We get these cases and we have to implement Jordan's Principle. We pay the money. Sometimes we don't see it again, but the bears, you know, that's what they're there for. That's what we use our money for, is to help these families. And we hope we get reimbursed. But when that's happening on a broad scale, that can really put you in a bad situation, which is what you're experiencing. I would write a very clear letter to the minister identifying the nature of the problem and its impacts on children. And I would copy that to all the parties of the Canadian Human Rights Tribunal. And you can also speak to the Chiefs of Ontario. Ruby Miller is there. Also Grand Chief Joel Abram, and their legal counsel, Sinead Dearman or Maggie Wente. And just make sure you're bringing these issues to their attention so that they're able to translate these problems into solutions at the negotiating table and put pressure on Canada in the interim. I'm going to put our email in the chat. And I would say this to everybody, we have such little capacity, but if there's a real entrenched problem you're experiencing, get a hold of us. We try to do what we can to advocate with you for the needs of your children to be met.
Thank you so much. I appreciate that.
Oh, miigwech. That's awesome, Cindy. I believe in as a community navigator, if I don't have the answer, I'll definitely find somebody who will. And that's great to see that in action right now. And I'm sure our auntie appreciated that as well. Can we have a big round of applause for Miss Cindy Blackstock? Appreciated that as well. Can we have a big round of applause for Miss Cindy Blackstock? Any last words?
I just say, like, we have collectively all worked so hard to make the world a better place for First Nations children and families in Child and Family Services and Jordan's Principle. And a way to use a football analogy, because I got 4 nephews, is we're really at the 10-yard line. What we need to make sure is we don't drop the ball now. I was taught by people who are much wiser than I am that the time when you're most likely to lose is just before you win. And we need to make sure that we see this thing through completion so that we set all of you up for success, so that money and money rules are no longer a barrier to you meeting the needs of your children. So please ask us to do what is required to make this, to end this in a good way that honors the survivors and that honors all the children, past, present, and future. Thank you so much for having me. I'm going to go out into -17 weather here in Regina, so make sure you find your winter coats because it's coming east. All the best to all of you.
Miigwech.